A recent hearing before the Karnataka High Court has sparked a wider debate about crime, punishment, and the language used by those who dispense justice. While refusing bail to a 23-year-old rape accused, Justice R. Nataraj orally observed that law has lost its teeth and went on to remark that perhaps people would comply with the law only if punishments such as chopping off a hand or a leg were imposed. At the heart of the debate are several difficult questions. Can a democracy committed to dignity, due process, and fundamental rights even entertain the idea of corporal punishment? Do tougher punishments actually reduce crime? Or is it the bigger problem, weak investigation, delayed trials, and low conviction? To discuss the legal, constitutional, and societal implications of these observations, we are joined by High Court Advocate Anwar Ali. Thank you so much, sir, for joining us. Now, we do understand that Justice and Nataraj comment that people will comply with law only if punishments such as chopping of hands or legs were imposed. It's an oral observation and not a judgment,
Yeah.
really. But legally, how significant are such comments while hearing?
No, this won't come directly from a judge. He's also a part of the society. He sees every day a number of cases before him gets listed, and it is not a nomenclature that he has passed such a statement. It is obvious to see when, as a judge, when I'm observing a number of cases coming before me, whether it is for the purpose of bail or for the purpose of quashment or challenging the FIR or any other proceedings for that matter. When particularly crime cases are before me as a judge, I would see a case that a reformative theory is not working out. The number of cases are increasing. The hooligans, gundas, and these persons who are involved in heinous offenses, such as the same matter which was referred to, was a matter pertaining to rape. Now, I do have sisters. You are also my sister here. I have to be very careful about protection of women. Now, to come to the conclusion in that matter, I have to see as a judge how I can eradicate these issues. Now, to eradicate these issues, rules should be stricter, stringent in nature. We should have a lessons to the people who are living outside the society, who are not in the jail, or say for that matter, who are in the jail also, that they should not commit such an offenses. Not to commit such an offenses, we should have a stricter rules. We should have a stricter punishments. We should require to have a prosecution being strong. But if we see from the past, the crime rates are increasing in India. The National Crime Record Bureau records the history that the number of cases registered under the crime, that is IPC or now BNS, are rampant in nature. Now, how these crimes are going to be stopped? If the convictions are more, if the punishments are stricter in nature, then only these are going to stop. It is not only a matter of rape. There are so many offenses of such a nature where the punishments are very less, or say a human made punishment. These all laws are being passed in the parliament. Because of that, we are having a maximum punishment up to life or 7 years or 14 years. So because of these, they are unable to come to some conclusion that they cannot eradicate the crime from the society, and those who are committing these offenses are very free. They are roaming like heroes. To come to such conclusion, that is to say that we should eradicate the crime from the society, a reformative theory is not going to work, which is what my considered opinion is. Now, comparing the Middle East laws with respect to India is concerned. Now, the crime rate in other countries, in Middle East, for that matter, which is being taken as a part of discussion, now the crime rates are very less, thefts are very less, rape cases are very less, because they take off their limbs, they take off the eye for an eye, blood for a blood. People will fear. They won't go for commission of such offenses. We have seen so many case laws in history coming from various renaissances, where eye for an eye has taken place in the society, which has concluded to eradicate the crime from the society.
Right.
Now, giving such a remarks, in my personal opinion, is not a bad remark. It is required. If we have stricter laws, we can have a better society. If we do not have a stricter laws, if we do not have a conviction rate to the peak, then definitely we are going to promote these so-called um, criminals as a hero.
Also, coming back to the comparison with Middle East, there we understand that there is Sharia law that is being practiced, and there are various other aspects that are very different from Indian democracy and our constitution. So, is this is this even a right comparison over here?
We have adopted Indian constitution by securing from various, or to say by studying
Adopt, yeah.
various different countries' constitutions. And when we have also adopted Indian Penal Code, we have also have referred to various countries' punishments. Now, making a comparison with the other country laws is not bad in the eyes of law. We should have a comparison. Only then we can come to some betterment of the society. This is one aspect of the. And another aspect is, if we do not compare, or say, if we do not give a proper reasoning to a particular statement, then development, or to say that amendment to that effect, will not come into existence. We will certainly have a rule of law in a stationary manner. This is a law which is not stationary in manner. It goes on changing according to the changed circumstances as per the demands of the society. But what pure democracy, what we do not have actually here is, it stands on the will of the people. But we have a federal society, we have federal laws, constitution along with the federal society, which will pass the laws according to the parliamentary proceedings. Now, these parliamentary proceedings, if we go through the study of parliamentary proceedings, they will not make, or they will not enact laws without referring to any other laws. They certainly refer to. The same thing judge also has done. There is nothing wrong in referring to the laws. Now, what is Sharia to be taken into quote unquote as a Muslim law as such? Sharia is a term used in Arabic to say rule of law. What we say here is Kanunu in Kannada, or in Hindi, Kanun. So Sharia is nothing but Kanun. They are referring to a law which is implemented in the Middle East, which is stricter in nature, and they are also observing the results of it. There is nothing wrong in comparing the laws in respect of Middle East is concerned, or in respect of America is concerned, because we in American penal laws, we have seen 120 days, 120 years imprisonment, 160 years imprisonment. In Italy, recently they have given 400 years of punishment for one chemical company. There are such laws. There is nothing wrong. If the same was connected or taken example as a European countries, whether this debate would have taken place or not is also another question.
Right, depends on which country and where we come from matters there.
Yes, yes, yes. The debates also takes place according to the wills and whims of the demand of society.
Right. But also, can corporal punishment such as amputation ever be compatible with the Indian constitution, the values of Indian constitution?
No, not in that manner. We have a federal democracy which speaks about having laws in respect of now say for example, the Indian Penal Code gives a particular punishment, that is BNS now gives a particular punishment. This punishment is given by human made law, that is by way of parliament, by legislating the parliament. Now, who gave these people a right to kill somebody by way of execution, or put someone behind the bars for 14 years or 20 years or 60 years or life imprisonment? This is also a kind of punishment. The only difference is they are giving a harsh punishment and you are giving a soft punishment in the form of reformative theory. But a person who is not ready to reform himself, what kind of reformative theory you are going to apply? The fear is required to be inflicted in the society. A message should go in the society that if I commit a wrong in this way, then I will be dealt in this way. Then only people will fear. They will not commit offenses. Now, Middle East countries, if a person is stealing something, he will be dealt with chopping of his hands. If we are not applying this in this country or any other country for that matter, whether stealing is going to stop. Question is how we can eradicate the crime from the society. Now, to eradicate the crime from the society, even if we take another 100 or 200 years of reformative theory, this is not going to work out. This is my considered opinion. Because we are not into stricter law nature. We are into reformative nature, which is causing us, instead of eradication, it is increasing. The crime rate is increasing.
But also when we talk about crime rates in general, it's not just a factor of just the judicial process, but there are a lot of factors that come into play, like the economy of a society, the time of the punishment, the judicial process in general, and our judicial process does take a very long time in general. There are many cases pending in the court. So do such remarks by the judge during a proceeding, does it also influence the public opinion and how the case is being perceived?
It ultimately depends upon a case, here and again.
Yeah.
Because the pendency of cases is a question to be asked. Honestly, I do on the same path. But because of having lack of judges, one point. Second, we have a collegium system where judges appoint judges. Thirdly, we have benches of a High Court and Supreme Court where required number of judges are not working.
Right.
The pendency of cases are more. The allotment of cases to minimum judges with a minimum criteria. They are also human beings. They cannot go and work beyond their limits.
Yeah.
However, they are working yet. Karnataka High Court is, of course, doing its best compared to the other states. But yet, question remains. The pendency of cases, a question remains. That is required to be answered by the judicial itself. However, they are doing their best to resolve the issue. This is one aspect. Another aspect is the duty casted upon advocates also. We have to take the cases on board as and when required. We have to run the cases day to day. We have to seek the dates from the judges day to day. That is also a part of an advocate. Even then, doing, I have also personally gone through it. Even after moving memos for board, we won't get it listed because the lists are already prepared. When a judge is hearing 100 matters, 200 matters in a day, and if I am moving another memo, maybe it will not reach the day. He may end up his session by the day when he is reaching to 150 cases. We have a Sachin Tendulkar judge in our Karnataka High Court. Proudly, I would say Justice Nagaprasanna. He reaches most of the time he has reached 300 cases a day. He is doing his best. There are many judges who are doing their best, but ultimately we all are human beings. Some things that cannot be controlled. Now, this is not a reason for the persons to commit crime. This cannot be an excuse for the people to commit crime. Merely because judiciary is slow, this will not give rise to other persons. If we have a stricter punishments, certainly, though number of cases are pending, but one judgment will certainly change the fate of the society. One conviction will certainly change the fate of the society. That is a stricter punishment.
So, do you believe that stricter punishments in India, which are more physical in nature rather than just being reformative, can prevent the increasing crime rate in the country, because we also see, like in certain cases, especially rape cases, like if we take the example of 2012 Delhi gang rape case, there was a lot of uproar, and it was a faster process in general as compared to the other cases, and there was a very strong judgment over there. But we still do see that rape cases, irrespective of the nature, keeps happening in every part of the country for that matter. uh, so would it still be effective in India if there are stricter, more physical punishment?
We have witnessed number of cases where media has also played a very crucial role
Yeah,
in projecting those cases when the matter is sub judice. Uh, Even then, we have seen the media trials wherein lot many things have happened.
right.
Take for example that actor, Bollywood actor
Sushant Singh Rajput.
Sushant Singh case. Yes, ultimately what happened? They have ended up in acquittals. These things need to be controlled properly. What is required to be informed to the society is required to be informed, which is not being discharged from the media houses also. When the matter is sub judice, when the matter is before the court, what court has observed, only that has to be informed to the people. But what is happening right now in India, what is to be called as a so-called fourth pillar of the democracy, it itself has spoiled because of heroing natures. Today we have seen Gujarat rape convicted people. When the
Bilkis
state
Banu.
government has decided to um, leave up them, they were garlanded, they were welcomed. When the people who have committed heinous offenses and they got bails, the processions are taken place on the societies to welcome them. So such things are required to be stopped by the law and order. It is a duty of the government.
Right.
Everywhere judiciary cannot enter into. Judiciary will enter into only when they receive cases on their bench. They will not go on the ground. But further, I would say the judiciary is also required to be enter into suo motu whenever it is required to protect the interest of the society, which is not done lately. What I have experienced, except the case of a stray dog issue. We have so many other issues also. We have hate speech cases. So we have number of defaming cases, morally harassing cases, economical boycott cases, social disturbance cases. But nowhere the Supreme Court or the High Courts have interfered suo motu and taken any stricter action to be implemented by the government. So these things are also on the one or the other way supporting the criminals.
Right. But coming back to this case, can such remarks influence the fairness of ongoing proceedings? Because we understand this was a bail appeal in this case. We still, the accused hasn't got the punishment. It's still, the proceedings are going on. So can it influence that?
It will not certainly influence because the trial is altogether different proceeding. The High Court's observation in respect of bail application is a different proceeding. We have seen, you might have gone through many of judgments where lastly they observe
Yeah.
that the observations made in this course of application should not be influenced, or the trial court should not get influenced by the observations made by this court. It should decide by its own. These are the observations which are also being made while passing such orders. Now, this being an oral remark, it will not affect in any manner to that particular case. The case will completely be decided based on the evidences led at the time of prosecution. But such remarks are, I believe, required to protect the interest of the society. People should think of before committing any crime. Government also should note of such remarks and come with the proper particular stringent laws so that people should not commit such offenses.
So the judge suggested that democracy is sometimes taken for granted. Uh, do you see any merit in that concern?
democracy is taken for granted is in such a metaphor. We have a democracy, but not ultimate democracy. The Turkish country once had a ultimately pro-democratic nature, but we are not completely democratic. Democracy means a theory which speaks about completely power lies with the people. But here, power doesn't lies with the people. It is a federal democracy. We have a government where parliament legislates laws. The executive officers are there, executive department is there who is execute the law, and the judicial officers are there. The separation of power principle is adopted by us. So it's not completely democracy. It's a democratic nature which is taken for granted what is being said. I believe that I being a person who has the right to cast my vote, taking my right for some right on the aspersions of somebody, and this is being committed, done, not because a personal or a particular individual is exercising his right, but because he is being provoked, he has been prompted, and he has been involved in such a mental slavery for which a government is responsible.
Also, when you see that, we talk about this, does the constitution, Indian constitution, prioritize deterrence or human dignity for even stringent punishments to be a part
Certainly,
of the
certainly everybody has a right. Everybody has a right. Even accused has got a right. Even a dead person has got a right. How he has to be buried or how he has to be cremated. He has got a right. But we have exceptions to the fundamental right.
Hmm.
The fundamental right cannot be given to everybody. When a person is committing offense, now he cannot hail for the fundamental right. His fundamental rights will cease to operate the moment he commits something against the constitution. So it is not a privilege. It is not a privilege every time. But certainly it's a fundamental right when you are right. When you fail to exercise, when you fail to discharge your duties which are towards the constitution, then it's not your fundamental right. It's a privilege which will be given to you at the will and whim of the judiciary or the will and whim of the government.
Also, talking about the crime rate and the severity of punishment, in this context again, what actually deters crime more? Is it the severity of punishment or the certainty of punishment? Because in India, we also see that a lot of times the process itself is becoming a punishment in general, where years go on and there is no punishment, or it's so late that it feels like it does not matter. So, what is more important in your opinion over here? Severity or certainty of punishment for crimes do not happen?
It again depends upon the cases. We Indian history has now again and again witnessing number of acquittals when people have spent their lives. After 24 years, he's acquitted. After 50 years, he's acquitted. He has lost his youth, his adultness completely behind the bars. Now, who has to be held responsible for this? The government has to be held responsible, or the judiciary? Ultimately, these are the questions which leave us think of. These are the things which will prompt in a person who has never committed anything but was subjected to incarnation. He has spent his life behind the bars. These are also things which will make a person criminal. Wantedly or unwantedly, nobody will become a criminal. But there are some things. Some honest people are there in the society who are leading the society. When those people are kept behind the bars for one or the other reasons, whether it's for the people who are heading the student campaigns or for the reporters, news reporters, there are a number of people who really think for the nation are kept behind the bars today. They will become one or the other way revolutionary, and ultimately the judiciary and the government is responsible for those things, for not granting. When case of a high elite is before the court, we see the observation of one day is too many. in Arnab Goswami case, Supreme Court says. When other person cases goes before this court, we see such an observations which make us laugh. I mean, we can see to it, clearly see to it that there is one or the other distinction between two people.
Yeah.
Even today, we are practicing caste names being mentioned in the FIRs. What is the purpose of it? No purpose, no use of it. Criminal is a criminal to whichever race, sex, caste, religion he belongs to. He is a criminal. But yet we mention the name and caste, religion of that particular person in a FIR. Such practices are not required to be practiced in today's so modern society. But these things are lacking.
So what you're saying is that though the remark made would make more sense in our country because we have a reformative practice, but at the same time, the changes from the government and overall lack of judicial processes, the other systemic problems that exist needs more reforms for crime rates to eventually. Is that right?
It will go eventually, because what I would say is, when the parliament can enact laws to give a capital punishment, when a person can be executed by hanging, then why can't he be chopped off? It can also be brought by way of parliamentary legislation. What I feel as a rigorous may not be rigorous to somebody else. So the same way goes. When we are giving a capital punishment, that is a death punishment, it may be rigorous to somebody else. So merely because we have a constitution and we are adopting to reformative theory, if that is not working at all, then we have to think of some stringent theories. We have to move on.
But yeah, like our constitution does not permit such uh, punishments.
Co- Constitution doesn't speak about punishment. Constitution speaks about the structure of a country, how the structure has to be maintained, what are the basic foundation of the constitution, how it has to be adopted. It speaks about the very nature of a state, how it has to be maintained. If we go through the preamble, it speaks about we, the people of India, having solemnly resolved to constitute, etc., etc., etc. This will, in any manner, doesn't come in way of implementing or bringing legislation to giving stringent punishment. Constitution will not stop anybody from making laws for the betterment of the society. So I said, capital punishment, maybe we are thinking it's easy, okay, fine. But the same punishment to some other country, they may be feeling it very stringent, like we are feeling stringent to the Middle East punishment. The ultimate conclusion is how we can eradicate the crime, how we can at least reduce the crime. By what means? If reformative theory is not working out, then we have to think of for something else.
So
So stringent laws are required. Accordingly, the statement stands.
before we conclude, what could be some ways that, in your opinion, that India could reduce crime rate apart from stringent punishments, as you mentioned about it?
Don't look at the Middle East as a Islamic law or as a Sharia. Look at it as a law.
Hmm.
There is one country which is executing its people for commission of some, and because of that execution, the crime rate in that country is very less. So whether in such a pattern should we adopt or should we not adopt is a question. So in that aspect, if a judge says that if we had such a laws, the crime rate would have been reduced. If we take it in this context, what judge has said is right.
Thank you. Thank you so much for your time and your interpretation. Thank you.